best practices for content owners and sharers of IP works on social media. I'm Erica Van Loon. I'm a partner at Nixon Peabody, where I do all manner of work for people who are being sued for infringement or for authors to protect their works through infringement suits. And I also provide counseling. So today we're going to be talking about mostly copyright. So we're going to go through what is protected under the Copyright Act in the United States and how copyright owners can protect their works. We're also going to talk about how you can safely share content created by someone else if you are not the creator of the work. And we're going to talk a little bit about some other IP considerations, such as trademark and right of publicity. So first off, what is a copyright? So copyright protects any original work of authorship that is fixed in a tangible medium of expression. What do I mean by fixed in a tangible medium of expression? Copyright does not protect the idea of something. You actually have to express the idea. For example, you could have an idea for a song, but that's not protectable. But if you write down the lyrics to the song, or you compose the music for the song, that composition or the lyrics that you write down on paper or on your computer, that is protectable via copyright. So lots of different types of things are protectable: literary works, books, articles, musical and dramatic works, dance performances. That's been coming up a little bit lately about how much of a performance needs to happen before it can be protectable via copyright. For any of you that are video game fans, the Carlton dance has recently been subject to copyright suit. Carlton, the performer from The Fresh Prince of Bel-Air, claiming that he had copyright protection in the little Carlton dance. That hasn't been decided yet, but it is my opinion that that is too short to qualify for copyright protection. Other types of works include pictures, paintings, obviously songs, film, video, and architectural works are some of the things that can be protected via copyright. What is not protected via copyright law? The titles of books are not protectable via copyright. We have to keep in mind the First Amendment as well as copyright. All of these different laws intersect with each other. As I mentioned, short phrases cannot be protected. Facts and ideas cannot be protected. This comes up a lot. You know, you can write a book, for example, about World War II, maybe about a battle in World War II, let's say the D-Day invasion, but you can't own the fact that the D-Day invasion occurred. You can only own your particularized expression of a story that took place at that battle, for example. And certain works by the US government are not subject to copyright protection. Other things that are not protected are works that have fallen into the public domain. Works do expire eventually. It's a long life that a copyright has in the United States, but eventually they do expire. Probably one of the most famous examples of that is the Happy Birthday song that is in the public domain. So feel free to sing it. So as I was mentioning, the creator of the work is generally the owner of the copyright. The duration of copyright rights is the life of the author plus 70 years. So once the author passes away, there's 70 years more of protection for the work before it goes into the public domain. However, there are certain exceptions. For example, works for hire, works made for hire. what that means, the most typical example is, for example, if you work for a company, you're an employee. Well, anything that you create on the company's behalf is owned by your employer, not by you. That's a work for hire. Another example is an author can transfer title of their work. You can license your work, and you can decide the terms of that license to give permission to others to use your copyrighted work. Or you can assign full right, title, and interest to the copyright to somebody else. So sometimes the owner of a work isn't actually the creator of the work. Now, in the United States, copyright protection arises the moment that an author fixes a work in a tangible medium. This means you don't necessarily have to have a copyright registration in order to have copyright rights and copyright protection. However, it is a very good idea to register your work with the U.S. Copyright Office. There are several benefits to doing so. First of all, you're creating a public record of your right to copyright in whatever the subject matter is that you copyright. So you're providing notice. And very importantly, there was a decision out of the United States Supreme Court a couple years ago that stated that you are required to have a copyright registration in order to bring a lawsuit for copyright infringement. It used to be a little unclear as to whether you could have a pending application versus an actual registration to move forward with suit. But in the Fourth Estate case, the Supreme Court decided, no, you actually have to have a registration in order to sue for infringement. And very importantly, when you have a federal copyright registration, this allows you to recover statutory damages. Now, statutory damages are damages that are codified in the Copyright Act. So, for example, if you have somebody that you're accusing of non-willful infringement, maybe accidental use of a copyrighted work, under statutory damages, you can get up to $30,000 per infringed work. Now, if you can prove willful or intentional copyright infringement, then the amount of statutory damages can be up to $150,000 per infringed work. And this is really important because a lot of times in copyright cases, it can be difficult to ascertain the amount of damages. Sometimes it's really hard to prove what the loss is to the copyright owner. For example, if you have a photograph and it gets shared around online, sometimes it can be difficult to quantify that number of damages. So having the statutory scheme really helps to be able to get an amount to help make the copyright owner whole. It's very easy to register online for a copyright. It's through the Library of Congress, and you can go to copyright.gov. There is a small registration fee. It is $35 for a single author registering a single work, so not too expensive. And there is an application that you need to fill out, and then you have to upload a digital specimen or deposit with the Copyright Office showing specifically what you're registering. There have been some recent cases on this too. I mean, it's always great to consult a copyright attorney to make sure that you fill out your application correctly, especially if your work consists of underlying portions that weren't created by you, which happens a lot with software code. Sometimes you have to figure out what you're registering and what is not yours that you can't register. So it's always good to consult an attorney. But the good news is the Supreme Court recently ruled in a case against H&M that a mistake in the application will not necessarily invalidate registration. So that can give some peace of mind. Now, one thing you need to remember when you're registering your work is that what you're protecting is the specific specimen that you upload with the Copyright Office. So a lot of times what happens, let's say, for example, you have a screenplay and you register a version of your screenplay with the Copyright Office. That is what you're seeking protection on. Now, let's say after you register that, you go and you revise the script and you make a bunch of changes to it. You want to make sure that you re-register your revised version so that you're protecting the most current version of the work. And luckily, since the registration fee is only $35, you can go ahead and register a first version and then register subsequent versions as you make changes. Again, this comes up a lot with software. And sometimes you want to register your earliest version, but then as many changes are made, you want to make sure that you continue to update your registration. It's very important to protect your work. Your rights aren't absolute. One thing you need to think about critically is to pursue any claims you may have against a would-be infringer before it's too late, or you could waive your claim. The statute of limitations for copyright infringement in the United States is 3 years from when you knew or should have known about the infringing activity. So that can sound like a long time, but you'd be surprised. 3 years can come and go pretty quickly. So if you think, if you're a copyright owner and you think somebody is potentially infringing your work, typically what we do first is we send a cease and desist letter to a potential infringer. And many times sending a cease and desist letter can begin a conversation between you and the would-be infringer. And depending on what your goals are, a lot of times that can resolve the dispute. It could be as simple as asking the infringer to take the work down off their site. It could lead to a negotiation between you and the potential infringer for a license. So maybe you can monetize their use of your work. There's lots of reasons why you can send a letter first and see if you can resolve the dispute before turning to the court system, which can be very expensive and also slow. I should mention they are putting together a copyright small claims court. It hasn't actually started yet, but it's going to take effect soon, I think later this year. And this will be a way for copyright holders to pursue smaller claims against infringers without having to use the federal court system, which can be slow and expensive. So that's one thing to look out for. Another cool thing with the rise of blockchain technology, which is involved with many things right now, like cryptocurrency. This can be a way for you to protect your copyrighted works online. You can use blockchain, and that's a whole other discussion, but generally speaking, blockchain it creates an encrypted ledger, which allows you to see everybody who's uploading your work and where they're uploading your work, so you can track the use and be vigilant about protecting your rights if somebody unauthorized is posting your work online. There are several service providers that help you employ blockchain. This typically comes up with photographs or videos that are shared online. And so there's some service providers I've mentioned there, but there's lots of companies that are doing this right now. So it's one thing to think about. If you have, something that you think is going to go viral or get disseminated digitally, you might want to consider blockchain as an added form of protection to registering with the Copyright Office. So now let's switch gears. What if you are not the content creator, but you want to use content that was created by somebody else? As I mentioned, the author of the work, they have copyright protection the minute they express their idea in a tangible medium. So they don't have to have a federal registration in order for, what I'm trying to say is that doesn't absolve you. If they don't have a federal registration, you can still be infringing on their rights. So Obviously, the safest thing is to be really careful when you use content of another person. If you don't have a license to use the photograph or to repost the article or the video or whatever it is, don't do it. If you want to be able to use it, reach out to the copyright owner and try to obtain a license to be able to use it. There are some works that you can safely use. There is something called the Creative Commons, where people allow their works to be shared freely online. There's the public domain, which we mentioned earlier, which consists of works that either aren't entitled to copyright protection at all, or a work that was once protected but now has expired because it fell into the public domain, usually because it's really old, but sometimes maybe there was a problem with the renewal process under the old Copyright Act and it fell into the public domain. There's also open source. And so this comes up a lot with software code. There's all these programs out there. There's, Linux, Firefox, and JavaScript, where you can use open source and then you can build from there. And in those situations, I think it's really a good idea to consult with a copyright attorney to figure out what portions of your code are protectable and what aren't. And also when you're using someone else's code that's based on one of these open source platforms, it's really important to look into it, because it's not necessarily free to use if it's open source that's been modified and transformed. So copyright protection is international. There is a convention called the Berne Convention. This was a treaty that was enacted actually back in 1886, but the US, interestingly, did not join the Berne Convention until 1989. And the basic principle is that countries that are signatories to the Berne Convention, they give reciprocal copyright rights to each other. So, for example, if you have a Korean copyright, you can enforce it in the US courts. And likewise, if you have a US copyright, you can enforce it abroad if the nation that you want to pursue an infringement action in is a member of the Berne Convention. And most countries are at this point. It's still a good idea if you're creating the work here in the US. It's a good idea to have a US copyright. All the statutes around the world are a little bit different in terms of, what's considered, if there's statutory damages, what the statute of limitations are. This is all different in every country. So, if you are creating the work here, or planning to distribute, copy, share the work here, it's a good idea to register it here in the US. So going back to using works created by others, you can't sidestep an infringement claim just by crediting the source. So for example, if you're sharing a photograph online and you say the name of the photographer, that's not enough to absolve you of infringement. So you still have to have a license to share the work. If it's unlicensed, you can be liable for copyright infringement. Now, all of my clients, when we're dealing with copyright issues, the first thing that always comes up is fair use. Oh, if I'm representing a defendant and they use the content of another, I think it was a fair use. And what is fair use? Well, I'm here to tell you that the fair use doctrine is really, really gray in the US. It's a very amorphous standard and it can be hard to apply. And we'll talk a little bit more about it. But basically, there's 4 factors in the Copyright Act that are considered in determining whether or not a work is a fair use. The court looks at the purpose of the use. Is it commercial? Like, are you trying to get money for using the work of another, versus is it educational? Is it newsworthy? Is there some other exception that might apply? They look at the nature of the copyrighted work. That just really means, is it subject to copyright protection at all? The courts look at the amount of the copyrighted work that's used. Are you using just a tiny portion of it, or are you basically putting the whole work online out there? And they also look at the effect upon the market or value of the copyrighted work. Again, are you trying to monetize it? And if you're trying to monetize it, are you taking away revenue or license fees that could be going to the copyright owner? So again, this is just a warning that this is a really tricky area of the law, and you have to proceed carefully. So I think the best way to illustrate fair use is with some examples from some of the case law. So here's an example that I think is kind of interesting. This is a very famous case from the Second Circuit, and the Second Circuit covers New York. In California, we are in the appellate court district of the Ninth Circuit, and you will find that most copyright law comes out of the Second and the Ninth Circuit because a lot of creative people live in California and New York. So in this case, the picture on my left, just the plain black and white picture, was taken by a photographer named Carew. And then Prince, the defendant, you can see he made some changes to the original photograph. He added an electric guitar. He put sort of like a funny face on top of the person shown in the picture. And that's about it. That's all he did to change this work. Now, what do you think the court said? Do you think that they said that this was a fair use, or do you think that they said that this was an infringement? Well, many people, including lawyers, were very surprised when the Second Circuit said that this was a fair use. They found that the work where the guitar and the image on the face was added was, quote, transformative and created a new expression, meaning, or message to the work. So this qualified as a fair use, and Prince was allowed to sell the image you see on the right. It's a very controversial decision. Same circuit, this was last year. This was also in the Second Circuit. We had another case dealing with fair use. And so in this one, we have the original photograph, the black and white photograph of Prince, who I love, and I'm sure many of you love. He's a great artist. So that was the original photograph taken by Andy Warhol. And the defendant made the changes that you see on the right, changed the background of the picture, added some color, but it's still the same photograph. So in this case, the Second Circuit ruled that the changes made by the defendant were not transformative. So what's the takeaway? This is a fair use. This is not a fair use. So this is what I mean when I say it can be kind of tricky to navigate this stuff. Here's one more example from a very recent case. This was the Dr. Seuss estate sued a company for doing a mashup book of the very famous children's book, Oh, the Places You'll Go. So on the left, you can see this is from the original Dr. Seuss book with the little Dr. Seuss characters walking there. And then you see an image from the mashup on the right. And basically, they've changed the Dr. Seuss characters to look like Star Trek characters. So in this case, this was in the Ninth Circuit in California. And originally, the district court found that the defendant's changes were transformative. So the district court found it to be a fair use. It went up to the Ninth Circuit, and the Ninth Circuit reversed and said, this is not transformative. This is not a fair use. This is infringement. So those are just some recent examples. We just went over this. This is the 4-factor test. But so just kind of putting it into context a little bit more, what do you have to do to transform something, to make it so different that it's kind of considered a new work and therefore not, not an infringement? Again, the touchstone of the fair use defense is always commercial use. If you are selling the work that you have transformed, that often weighs against a finding of fair use. But these cases they're really fact specific and they're really tricky. So another one that received or was considered very controversial was the Google Books case. So if any of you guys are familiar with Google Books, Google digitized millions of copies of books and made them into a text searchable database. And some of the authors of the books sued for infringement. This was a Second Circuit case, and the Second Circuit found that this was a fair use, that what Google was doing was okay because their copying, quote, served a transformative purpose because it created a text searchable database that communicated something new and different from the original. Now, I think what really helped Google out in this case was that when you were searching this database, you could only see a snippet view of the book. So at most, it was maybe like I think it was 3 lines from the book. It wasn't very much of the entire work. And I think that's what really helped them tip the scales in favor of a fair use, because being able to search Google Books really wasn't the same as downloading and actually reading the book by the author. Again, we talked about this is another factor, the nature of the copyrighted work. And really this boils down to, is this something that's even a protectable expression or not? And it's interesting, what the courts find on these. So there's a case, Baker v. Selden, where somebody had created basically accounting template forms, and the court said, no, that's not protectable because that's more like the idea of an accounting method than the expression of an actual idea. So this is that idea expression dichotomy, and the court found that that just wasn't protectable copyright subject matter. Same in this other case, Morrissey v. Procter & Gamble. This is where the plaintiff was trying to say that some contest rules were protectable via copyright. And the court ruled, even though the defendant was using the same language in their contest rule, that's not really protectable. And this one, I have an image. This is from another case. Jewelry design is another thing that is protectable via copyright. And in this one, the court ruled that the idea of jewelry in the shape of a bee is really not protectable. Again, it's the specific expression. So what usually happens when you have an infringement case is the court ultimately conducts what's called a substantial similarity analysis, and it will compare the copyrighted work. So again, going back to what you registered with the Copyright Office, it will compare what the registration was for against what the defendant is doing and see if they're similar. And so these jewelry design cases, I've done several of them. I mean, they can be pretty tough for the plaintiff because, Lots of jewelry, for example, has commonplace designs like a heart or a star. And so to say that you own copyright protection in that image, it can be very difficult. It has to be a pretty ornate, particularized expression to be able to hold up in court against an infringement claim. So those can be very interesting cases. Again, the court in the fair use analysis looks at the amount of use. And we talked a little bit about the Google case and how there was that snippet view where you could see no more than 3 lines or 3 snippets per book. So the court ruled, well, that was a very small portion of the overall copyrighted work. So that's what tipped the scales in favor of a fair use. You can contrast that with, there's a famous case called TV Eyes, and this was Fox News Network versus TV Eyes. And TV Eyes basically allowed its subscribers to play clips from Fox programming. And these clips could be up to 10 minutes in length. So the Second Circuit looked at that situation. And unlike the Google Books decision, said, you know what, 10 minutes is a long time. You're basically allowing the viewer to see the entirety of the work. And so that's not a fair use. That was too much use of the copyrighted material. So those are some examples of that. Again, really, a lot of times it comes down to the effect on the potential market or value to the copyright owner. So going back to that TV Eyes case, I think that the fact that TV Eyes was depriving Fox of revenue, perhaps from commercials or licensing opportunities. It was a big factor in why the court did not find fair use in that situation. The court weighs all these factors together, but again, I think the commercial use factor is really the factor the court looks very closely at when deciding whether it's a fair use or not. So what are some of the takeaways from this? Well, try not to use other people's content unless you have permission to do so, of course. But if you are going to try to qualify for fair use, try to use as little of the copyright holder's content as possible. There are some exceptions, as I mentioned. Educational use can be a fair use. Newsworthiness can be a fair use. This comes up a lot, especially with YouTube videos and things. You have a something that happens in the news that day, and then people want to share a clip from an interview or something from CNN that happened that day. That can often be considered a fair use because it falls within the newsworthy defense. The problem people run into a lot of times is they continue to keep that content up on their site. So maybe the day that the story broke, or maybe for the first couple days that story is newsworthy, okay, you've got a good shot at fair use at that point. But if you keep the video up on your site and it's something that happened a month ago, 2 months ago, longer, now you're not going to stay within the newsworthiness exception. That's not going to be considered a fair use. So think about taking content down after it is no longer newsworthy, to make sure you don't keep those things up on your site, because that's where you can get into some trouble. And again, when you're selling or monetizing the work, that's considered a commercial use, and that's going to weigh against a finding of fair use. And of course, we're just really talking about copyright fair use right now. There's also a fair use defense for trademark, which is a whole other panel discussion, but trademark can be implicated too. So you have to be careful when you're sharing content of another, and the content is not only protected via copyright, but there may be some trademark issues, or there may be right of publicity issues. So all of these different rights can intersect with each other. We already talked about that. Attribution, again, we talked about this. Attribution just means when you give credit to the person, the author of the work. This can kind of be a two-way street, you know. As I mentioned earlier, giving attribution doesn't absolve you of infringement. So just listing the name of the photographer or whoever wrote the article, that's not enough to get out from under infringement. And also, if you give attribution, it will be easier for a copyright owner to spot use of their works. So it can be complicated. Again, it's always best to have a license or permission from the author to use their work. Getting a license will preempt potential issues. And you would be surprised, licensing can be given out more freely than you might think. For example, if you guys are, if you have websites where you're using digital content, you've probably run across sites like Shutterstock. Shutterstock has, stock photography that you can use on your website, for example. And if you go to Shutterstock, you can get a license to use the image from Shutterstock. And you just have to be really careful to read the terms of the license to see what you can and can't do. I mean, often, you pay a fee and then you can use it on your website. That's okay. But what's not okay, and what I've seen some people do, is then they'll take that image and they'll go and maybe change it a little bit and then try to register it with the Copyright Office as their own. That's probably going too far. So, but a lot of these sites do make it easy, or there's a way to get permission. You'd be surprised. And also, you really have to think about the terms of use, the terms of service for some of these sites, because embedded within their terms of service are licenses. So for example, I just threw up some here from Twitter and Facebook and YouTube. They all have sort of the same use rules, which are that when you post something on Twitter, for example, and somebody retweets your original tweet, when you post something on Twitter, you are giving a worldwide, non-exclusive, royalty-free license for others to share your content. So that's already embedded into the terms of service. When you share something on Twitter, somebody else retweets it, they're allowed to do that. They have a license to do it. Same thing with Facebook. If you share something on Facebook, somebody else can distribute what you share within Facebook. That's the thing to remember. That's really the touchstone, is if you stay on the platform, you're okay. If you stay in the Twitterverse and you're just resharing, reposting something in Twitter, then you are within their license. Same thing with Facebook. Where the problems happen is you see something on Twitter, but now you're sharing it maybe on your personal website. So now you are not under the terms of use of Twitter anymore. But usually when you're within the platform, most of these sites allow a non-exclusive royalty-free license. Now, YouTube is pretty famous for people sharing copyrighted works of other people that they don't have the rights to use. And now YouTube also grants a non-exclusive royalty-free license to share the content on YouTube. The problem is if you didn't actually own the content to begin with. That happens a lot. And luckily, you don't have to run to court if you're the copyright owner in those situations. All of these sites, Facebook, YouTube, Twitter, Amazon, if you're selling goods, they all have takedown policies. So you can contact them if somebody is inappropriately using your copyright or your trademark. And they have pretty robust takedown policies where they'll just take the video down or take the posting down. And if you're okay with that, if you're not seeking further remedies like damages, that can be a pretty quick and easy tool to make sure people aren't using your work without permission. So this is just an example of, some of the stuff that can come up when you're using the copyrighted work of another. So I have an image up here. It's from a news interview. So obviously or maybe not obviously, but the video footage is owned by the station, NBC, ABC. They have the copyright to that. The reporter in this image is holding onto his questions and notes. That is protectable via copyright as well. Then on top of that, in this picture, you can see a lot of trademarks. You see Caterpillar in the background. You see the news station name on the microphone. That's all subject to trademark rights. So just showing there's an intersection of a lot of different rights going on, even in this one image we're looking at. Below this, we have a lovely picture of Justin Bieber. This is a mugshot taken when he was arrested. The good news is, or I don't know if it's good news, but mugshots are in the public domain. It's a government work. It's not protectable via copyright, so you can use a mugshot. Here's some other real life examples from social media. We were talking about this, but if you look on the right, we have somebody basically sharing they've embedded a link in, this looks like a LinkedIn post, and they're sharing a video from somebody named Jimmy. Now, if let's say, for example, we're on LinkedIn here and Jimmy posted this video on LinkedIn, and now this person is sharing the video that Jimmy posted to LinkedIn, no problem. You're under the license of LinkedIn. On the other hand, as I was mentioning earlier, maybe somebody uploaded to YouTube, I don't know, let's say maybe like a official music video of Taylor Swift, and they uploaded it. No, that you can't do that. You don't have permission to publish that. Taylor Swift people are probably going to use the takedown features to remove that video from the site. As I mentioned, this is a talk for another day, but in the back of your head, we've been talking a lot about copyright, but there's some other rights that come into play. There's right of privacy and right of publicity. This is basically right of privacy is, in a nutshell, the right to be left alone, and right of publicity is the right of an individual to control the commercial use of their identity, their name, their image. Just something to know about right of publicity. It's not just for celebrities. We all have a right of publicity. So, you have to be careful in republishing. You don't have to worry just about the photographer for example, that took a picture, but you have to think about the subject of the picture, and the subject of that picture has rights of publicity, and maybe they don't want you to republish an image of themselves, for example. And then, of course, there's trademark. Trademark is totally different than copyright. Trademark is a word or a slogan, and it basically has to do with having a brand identifier for your product or service. Think Nike, McDonald's. These are all famous trademarks. So as I showed you in the example above, you could have an overlay of copyright and trademark considerations when you're using the content of someone else. And that was basically my presentation.